Hi, my name's Vicky and I'm one of the solicitors at Genuine Legal and I specialise in family law claims. I understand that you have booked a consultation with us and that you're wanting some advice about property settlement. So do you just want to give me some background information?
Yeah, sure. So been married to my husband for the last 15 years, separated in the last couple of months. Two children, 7 and 12, who are living with me.
Yeah.
We have sort of discussed arrangements with them and have agreed that they will spend most of their time with me. Um, I guess what I'm just wanting to know is in terms of property, what I need to do and what I'm entitled to.
Okay, not a problem. The first thing I just need to explain to you is that as you are married, you can't get divorced until you've been separated for a year. So you'll have to wait 12 months from the date of separation to actually apply
Okay.
for divorce. And
Yeah.
then once you are divorced and the order is effective, you then only have 1 year from that date to do property settlement. So that's to reach an agreement either by consent orders or by a binding financial agreement. So currently there is no time limit, but the time limit starts ticking as soon as you are divorced. In terms of filing for divorce, it's a relatively straightforward procedure. You just file your application in the court. It can be a sole or a joint application. So sole is where only you sign it. Joint is where you both sign it. And then it gets listed for a hearing, and providing he has been served if it's a sole application or the application is done correctly, you will be granted a divorce. And then a month and a day later, the divorce order becomes effective. So if you divorced today, your divorce would be effective on the the 1st of July.
Okay. But I can't do that for probably 8 months from
Yeah,
now.
you've got to wait until you've
Okay.
actually been separated for 12 months, because otherwise he can respond and say you haven't been separated for long enough, and the court will probably refuse the application. So the time
Sure.
is important. So as soon as you're divorced and everything's done, that's it. The time starts ticking. Up until then, you can do property settlement at any time. So you could do it today if you wanted. You could wait a year and 4 months. However long you wanted is up to you. And then to deal with property settlement, the things that the court looks at, assuming you do consent orders, is they look at contributions. So what you brought into the relationship, your financial and non-financial contributions during the relationship, and then your future needs. So future needs are things like whether he earns more than you or you earn more than him, who the children live with, if there's some other reason why maybe you should get a higher percentage of the pool. And then the pool gets adjusted accordingly, according to all of those factors. So if we just go from the beginning, I can try and give you an estimate of what I think the percentage division of the asset pool will be. So at the beginning of the relationship, did you own any property, either of you? So that's real estate, motor vehicles, money in bank accounts, supers, anything like that?
No, well, he would probably have had a little bit of super and myself as well. In terms of real property, nothing, no houses, but we did each have a car.
Okay. And can you remember how much the cars were worth and what happened to them?
Oh gosh, they wouldn't have been worth very much, and I think they just got old and we just replaced them. Maybe $5,000 each.
Okay. And what jobs were you both doing at the beginning of the relationship?
So I was a nurse,
Yeah.
and he worked in finance.
And did he earn a lot more than you, or was it about equal?
No, he always has earned considerably more than myself.
And what job do you both do now?
So I'm still a nurse, and he's still in finance.
Okay. And what's your salaries roughly now?
Mine's probably around 45,000, and he's probably at 120,000.
Okay. Okay. And then, so what property do you actually own now? Do you own a house?
Yes, we do.
And is it jointly owned?
Yes.
And how much do you think the house is worth?
I'd say about 600,000.
Okay. And is there a mortgage on the house?
Yes, so I think we owe about 450,000.
And do you know what you want to do with it? Do you want to sell it? Do either of you want to keep it?
I mean, ideally, I'd keep it,
Okay.
because the children are established here. But that might not be possible, I suppose, on my income.
Yeah, because essentially what the banks would do in order to remove him from the mortgage, which is the primary issue, they would expect you to discharge the existing mortgage and refinance. So you need to be able to borrow enough to pay out the mortgage, and potentially if you had to give him some cash, depending on the rest of the asset pool, you'd need to be able to borrow enough for that. So what we would always recommend is that you speak to, say, like a mortgage advisor or to your bank, and to obtain some advice about what your borrowing capacity is.
Yeah.
Because that will play a large part in what you can negotiate. So it's always worth finding out if you can get finance approval.
Okay.
If not, if he doesn't want it and can't afford to keep it, then the house would have to be sold. And what we would do is we'd have to then work out on a percentage basis how much of those proceeds you get, because it wouldn't automatically be 50-50. It would be dependent on the remainder of the asset pool and how it gets divided.
Okay.
Okay, so do you have a bank account, and is it like a joint account or your own account?
We did have joint accounts until recently, but now they're separate.
Okay. And do you know roughly how much is in each of the accounts?
I'd say he has roughly 20,000, and I have roughly the same.
Okay. Did you just divide the money in the joint accounts equally, or is that separate money that you've acquired?
Yeah, we sort of divided it equally.
Okay. No problem. And do you have a car now?
Yes.
Okay. What's the make and model, and how much do you think it's worth?
It's a Ford Festiva.
Yep.
And I'd say probably $7,000.
And what about him?
He's got a BMW X5.
Yeah.
Probably 20,000.
Okay. And do you have finance on either of those cars?
No.
What about superannuation? How's that looking for both of you?
He's got about 190,000, I think.
Yeah.
Maybe a bit more. And I think I have probably 30.
Okay. And what about things like household contents? What happened to them when you separated? Did he take some? Did you take some?
No, so he's just gone and got all new things.
Okay.
And I've just retained the old things.
Okay, and how much do you think the stuff you've kept is worth? So it's like as a second-hand value. So if you sold on like Gumtree or Facebook, that kind of thing, rather than if you bought it new?
Probably about $5,000.
And do you have any expensive jewelry, artwork, or anything like that?
No.
Okay, and then for your liabilities, is it just the mortgage?
Yes, but HEX debt as well.
Okay. Is that both of you have a HEX debt, or just
no?
him?
So we paid off his in the relationship, but mine is still outstanding.
Okay. And then during the relationship, has there been any windfalls? So that's things like inheritances, compensation for any accidents or anything like that?
So there was an inheritance from my grandmother.
Yeah. And what happened to the money?
It went into the house.
Okay. Okay. So employment-wise, have you worked the whole way through the relationship, or have you had any periods when you've been at home with the children or otherwise?
No. So I've been at home with the children when they were both born for about a year following their births, and then recently for another year while they were small.
Yep. And he's always worked? He's not had any redundancies or anything?
No.
So would you say that he was the primary income earner throughout the relationship?
Yes.
Okay. And then how would you say it worked for the non-income aspects? Would you say that you've been the primary homemaker, that you've primarily looked after the children, or do you say it's equal?
No, so I looked after the children, the bills, the household chores, the shopping, the cooking, all of that.
Okay. And what are your plans for the future? Are you planning to go back to work full time, or what are you?
Well, I mean, at the moment, the children are still quite young, and I'm doing 3 days a week, which sort of works for our lifestyle. So look, I would think I'd maintain that for a little bit longer, and then, yeah, ultimately look to go back full time.
Okay. And then what would your salary be when you go back full time?
Probably about 70,000.
Okay. And is he still okay in his employment, likely to continue? Not any redundancies on the horizon or anything?
No, no.
Okay. Do either of you have qualifications that you mean you would be able to earn more than you currently do?
Well, yes, potentially for him. Yes, I would say so.
Yeah. So he could earn even more.
Sorry?
You think so? You're saying he if he used those qualifications, he could earn more than he is now?
Yes, yes.
Do you know why he's not? Is it just he doesn't want to work in that chosen field?
I think he's sort of put himself on a path where, you know, he knows that he will enjoy earning more money in the near future.
Yeah. Okay. And do either of you have any medical conditions or anything which impact your ability to work full time or to earn more money than you currently do?
No.
Okay, so based on what you're saying, my advice would be that you're probably looking at between a 55 to 60% division of the asset pool in your favour. That's based on the contributions and your future needs that we've gone through previously. Essentially, the court starts at a 50-50 position, and then adjustments get made in favour of one party or another. So you might get a couple of percentage for one thing, and then he might get a couple of percent for another, and then it kind of adjusts through. So we always start at 50-50, but that doesn't mean that's what the outcome would be. So I would say between 55 and 60%. If you could get between 50 and a low 55, that would probably be a good outcome if you were going through the court system because of the court fees that you would be incurring potentially. But you should certainly have 55 to 60 and you for negotiations and things. So the next step forward would be before going to court. So there's a couple of different routes. You can reach an agreement. You can do your consent order as your binding financial agreement, or you can file an application in the court because you can't reach an agreement. Either way, the court expects you to do a pre-action procedure. So that's the procedure where we write to him, we set out all the background information and go into more detail than I've done today. And we set out why we think you're entitled to what you're entitled to. We set out what we think the asset pool is and how we've calculated that. We ask him to say whether he agrees that's the asset pool or not. And if not, why not? And if necessary, we would say if there's a disagreement that you either need a valuation. So for example, if he says the house is worth a lot more or a lot less and you don't agree, then a joint valuation should be obtained from a registered valuer. And that means that it's usually you pay for it equally, although you can ask that he pay first and it gets taken into account when you do your negotiations. So that's where any assets are in dispute. That can even be household contents. It does, and vehicles and things. It doesn't just have to be the house. So that's one part of how we establish the asset pool. The other part is we swap your financial documents. The court has an expectation that you do full and frank financial disclosure. That's where you swap all your documents. You can reach an agreement without doing that. And you can just accept his values and he can just accept yours. And as you haven't been separated very long, you may be prepared to do that. The longer it goes on, the more you may say, I actually do definitely need the disclosure. But there is that obligation on both of you anyway. So if you went through the court system, you'd have to swap your documents. That's just the obligation the court places on everybody. And that's how we can also try and work out what the asset pool is. And then once we've done that, we can then say, well, we think you're entitled to say 60% of the asset pool. And then it's essentially a column exercise. We say what you want to keep, we say what he wants to keep, and then we work out through the remainder assets how you get your percentage. So that would be whether you keep the house or whether the house be sold and what amount of cash you should get, whether maybe you should have some superannuation transferred to you to balance up your super because he's got significantly more than you, or if he's keeping the house, how much cash he needs to give to you. And that's how we then can make an offer and we can negotiate. And if an agreement's reached, that can be the consent orders or the binding financial agreement. If we go through it and we can't reach an agreement, we find he's not responding, he's not engaging, then we might say to you, you need to do and initiate an application because we can't reach an agreement and ask the court to help. And through that process, the court will send us to mediation in due course. And we find that often matters can settle like that. You can also propose mediation now if you want. That is usually an effective way of finalising things if there's a disagreement, but we usually try to negotiate on paper at least first, because that's what the court expects us to do as well. If there's the agreement reached, then we can talk to you about the way to finalise your agreement. So consent orders have to be fair. So they have to be what the court calls just and equitable. So you could agree that you get 10% of the pool and he gets 90% of the pool, and the court's unlikely to say that's fair. If you, or it could be the reverse, or you could say, okay, well, it's 50-50, and the court might still think, well, that's a little bit not quite fair because of the asset pool and the disparities between you, but it's okay because the parties agree. So if we, for example, you did agree 90-10%, then you can do a binding financial agreement instead that doesn't have to be approved by the court. That's a bit more complicated because there's more aspects to it, and you would be expected to do disclosure on that stage. Otherwise, you run the risk of potentially the agreement not being fair. And with both ways forward, whether you do consent orders or a binding financial agreement, if you haven't seen his documents and he hasn't seen yours, it's very difficult then to change the situation. And go back to court and say, well, it's not fair. I didn't know he had a Lamborghini, for example, because you didn't look at his documents. So that would be the factors that we have to take into consideration. But we'll always advise you, any offer that comes in, we'll always say whether we think it's fair or not and whether the court's likely to agree it. You can agree whatever you want, essentially, but we will always advise you and advise you the best way forward, whether that's from doing consent orders or through doing a binding financial agreement. So that's essentially the process. And then in terms of what we can do, what we normally do is we'll send you a cost agreement out for the work, which we'll do. You can have a look at it, no obligation. You can decide if you want to go ahead, but we'll then get you to give us some more information, some documents, and we'll draft that pre-action procedure.
Okay.
Get things moving and to try and engage them in the negotiations. So we can try and
Great.
make an agreement for you.
Okay, thank you.
Okay. So do you think you have any?
No, I don't think so. I think you've answered all of the questions that I would have had. I guess, do you need anything from me next? What do you need from me now?
No, I have your email address, so I will email you out a cost agreement so you can take a look at it. If you've got any questions, you can always give us a call and we can arrange a follow-up consultation. We always offer that to potential clients if they need to ask us questions. Otherwise, if you just sign it, we'll open up the file for you and we'll get started. We'll just send you the forms you need to complete then, and then we'll assign you to a solicitor and a paralegal, and they'll do all the work for you.
Okay, great. Thank you.
Well, thank you for your time today, and I'll send that email through to you in a few minutes.
Thanks, Victoria.
Thank you.
Okay, bye.